Welcome to the first of 3 videos on proximate cause. However, before we begin our discussion on proximate cause, I want to turn your attention to a changing development in the professional landscape. In February 2026, at the end, the bar exam was given nationwide. If you were in a uniform bar exam jurisdiction, you would have taken what we called the Legacy UBE. Beginning in July 2026, there are 10 jurisdictions that will roll out the next generation of the uniform bar exam. So beginning July 2026, we will have the introduction of the next generation bar exam. That bar exam, the next generation, has been slated to be given in 10 jurisdictions. That's Connecticut, Idaho, Maryland, Missouri, Oregon, Washington State, Guam, and Northern Mariana Islands. If you look at the charts, you will see that those jurisdictions who have identified the adoption of the next generation bar exam are being phased in up until July 2028. I take a moment to interrupt the video on the proximate cause doctrine so that you can take a moment to identify the state that you intend to sit for your bar exam and see if and when your state plans to implement the next generation bar exam so that you know how to prepare yourself best for your licensing exam. That's all I want to say. We're jumping now to proximate cause. Today, with this video, we are going to finish the causation architecture in negligence and proximate causation, right? By the end of this class, you will be able to do 3 things on an exam. Number 1, you will be able to separate factual causation from proximate cause, also called in the Restatement Third of Torts, scope of liability. 2, you will be able to apply an algorithm to the Restatement Third of Torts, Section 29, which is the rule of law for proximate cause. And you'll be able to apply an algorithm for Restatement Third of Torts, Section 34, which is the algorithm for proximate cause when there is an intervening factor, right? And the last thing that you will be able to do at the end or by the end of this video series is to manage intervening acts without collapsing into this idea of, quote unquote, the chain broke. The chain that we're referring to there is the chain of causation. But let's get into the doctrine of proximate cause. Please understand, proximate cause is not a second kind of causation. It is not a second kind of causation. Proximate cause is the law's boundary line where the responsibility for the defendant's acts stop. In other words, even if causation, that's actual causation, stretches endlessly, the law limits the responsibility that the defendant will be charged with as it relates to harms of the plaintiff. And the limit focuses on the harms of the plaintiff that fall within the foreseeable risk that the defendant created. Okay? Once factual causation is established, the inquiry shifts. Once factual causation is established, the inquiry shifts. The question is no longer whether the defendant caused the harm. The question becomes whether the law will attribute legal responsibility for that particular harm. So, in the beginning, the inquiry is descriptive. That's with actual causation. When the shift occurs, the inquiry becomes normative, and that is with proximate causation. What do I mean by normative and descriptive? Actual causation asks a descriptive question, and here's what I mean by descriptive. What happened in the world? Right. Here's the question. Did the defendant's conduct contribute to the harm that is suffered by the plaintiff? Proximate causation, also known as scope of liability, asks a normative question. Even if the defendant's conduct contributed to the harm that is suffered by the plaintiff, how far should the legal responsibility extend? How far should the legal responsibility extend? Let me give you an example. A driver speeds through a red light at a busy intersection. The driver that speeds through the red light strikes another vehicle. The collision creates a traffic jam. The traffic jam causes someone to miss a flight. Missing the flight causes a business deal to collapse. The collapse of the business deal leads to bankruptcy. Each of those events follows the previous one, right? The chain is traceable. The driver is a cause in fact every step of the way, right? That's actual causation that could be indefinite, because once we have the collapse resulting in the bankruptcy could result in the loss of the loss of the house could result in the loss of your spouse and your family. That could wind you up in child support court. That could wind you up in jail if you're not able to child support, right? So the harm from that traffic jam just continues to build and build and build. But tort law does not impose liability for every ripple that naturally flows from the negligent conduct, or else, in terms of Cardoza and Andrews and Paulscraft, liability would continue indefinitely. Both justices agreed there must be a limit to the liability somewhere, while Cardozo suggested that the limit to the liability should occur in the first element, which is duty. Andrews, and now the Restatement Third of Torts, agree that the liability should actually happen in the causation element, specifically proximate cause, which is why the Third Restatement of Torts refers to it as limit of liability, also known as scope of liability, right? What creates the risk with speeding through a red light? What are the risks that are created by speeding through the red light? Well, there's several. There's risk of a collision. There's risk of bodily injury. There's risk of property damage. Sure, we could go on and on and on, right? But those are the risks. Now, is a missed flight aligned with collision or bodily injury or property damage? No. So proximate cause would not extend to the damage of the missed flight. What about failed commercial negotiations, right? The business deal collapsed. Is that a type of risk that we can foresee if you conduct yourself in a way that you run a light? No, we're not running the light. What did we say that some of those risks were? Collision, property damage, bodily harm. Oh, well, what about bankruptcy? Is that one of the risks of running the red light and causing the traffic jam? That's not a bankruptcy is not a foreseeable risk. So there wouldn't be proximate cause extension to the bankruptcy. What we're doing in proximate cause is we're drawing the lines of limitation. How far? What is the scope to which proximate causation will extend? Proximate causation will extend to those harms that are associated with the risk. If the harms are not associated with the risk, then proximate cause does not extend to those harms. Notice what we didn't say is that the chain is too long. We didn't say that the bankruptcy is too remote from the negligent behavior of running the red light. We didn't say that the business deal collapse was too remote, right? Too far away from the dangerous behavior that created the risk. That's not what we said. What we said was the harm of bankruptcy is not the kind of harm that made the negligent conduct of running the light dangerous. Adopt the language. Adopt the language. So let's go to the rule of proximate cause. You know, I like the rules. Let's go to the rule of law. The rule of law that we're using for proximate causation is the third restatement of torts, section 29. And the third restatement of torts, section 29 says, an actor's liability is limited to those harms that result from the risk. Harms that result from the risk. One more time. Harms that result from the risk. Okay. So under the modern formulation, which is reflected in the restatement third of torts, section 29, an actor's liability is limited to those harms that result from the risk that made the actor's conduct tortious. Notice what is being focused upon. Was the harm the realization of the specific danger that made the conduct negligent? Is the harm the realization of specific danger that made the conduct negligent? Operationalizing the normative boundary. If scope of liability is the normative boundary of responsibility, how does the law draw that boundary? Right? We already know if we are trying to establish proximate cause that we've already done what? We've already established actual cause. Right? The only reason we're going to get to proximate cause is because we've established actual cause. And in turn, if we've established actual cause, What else must we have already established? Breach. If we are establishing breach, what must we have already identified? The standard of care. And if we've identified the standard of care, what must we have already established? Duty. Get it? The only reason I'm getting to proximate cause is because I've established that there's a duty. I've identified the standard of care that's associated with that duty. I've established a breach of that duty. I've established the actual causation, which leads me to now the proximate causation. Get it? Fantastic. Once we get to proximate cause, we already know that the defendant actually or factually caused the harm in fact. Now we must decide whether or not the law will extend responsibility to that harm. Got it? So, and that decision reflects policy, fairness, and principles. Policy, fairness, and principles. So, the doctrinal question for proximate cause under the Restatement Third of Tort, Section 29, is this. If responsibility cannot extend forever, and we've already established that it can't, what principle do the courts use to determine where responsibility stops? Historically, the principle used was directness or temporal proximity, that's remoteness, physical distance, moral blame, foreseeability, risk alignment. So historically, those are some of the ways that the courts have made the limiting decision call, right? Well, that's great, but what are we doing today? Today, it's about risk alignment. Today, it's about risk alignment. Modern tort law has largely converged on one organizing principle: risk alignment. Liability extends only to harms that materialize from risk that made the defendant's conduct negligent in the first place. Liability extends only to harms that fall within the specific risk that made the conduct negligent in the first place. Okay, here's an algorithm. I like steps, right? Why do I like steps? Steps provide me with a sense of methodology that if I execute each time under the appropriate scenario, I'm going to get an answer that's reliable, right? I don't have to jump around. I don't have to hem and haw. I don't have to guess. I just follow the methodology of the method. In other words, I follow the same steps no matter the hypothetical. If I'm solving for proximate cause, I've got 3 steps. Here they are. Step 1, identify the risk that made the conduct negligent. Step 2, identify the harm that occurred. That's the harm to the plaintiff. Step 3, align the risk. Step 3, align the risk. How do I align the risk? I ask whether the harm is the realization of the risk. See how 1 and 2 are connected? Number 1, what's the risk? Number 2, what's the harm? Number 3, is the harm the realization of the risk? That is the 3-step algorithm to satisfy proximate cause. Number one, again, identify the negligent risk. How do I do that? I've got a fact pattern. How do I identify the negligent risk? You ask, what danger made the defendant's behavior unreasonable in the first place? What was the dangerous thing that the defendant did? What was the dangerous conduct that the defendant utilized? What was the dangerous behavior that is the problem that set everything in motion? And when you ask that question, you're looking for a specific answer. When you ask that question, you're looking for something that you can name in 2 or 3 words. It's very, very specific. It is not a long sentence. It's not a paragraph. What's the danger? Collision risk. What's the danger? Fire risk. What's the danger? Assault risk. What's the danger? Economic loss, right? It's very, very specific. That's step one. Step two, identify the harm. And you're going to identify the harm by category. How do I identify the harm? You can ask this question: what injury materialized? Really very simple, right? What injury materialized? So in other words, what was the harm? Was the harm fire damage? Was the harm bodily injury? Was the harm a criminal assault? Was the harm a highway collision, right? And do you see, I'm not identifying the harm down to the bare specifics. I am identifying the harm based upon a category. I'm identifying the harm based upon a category. Step three, align the risk to the harm. Align the risks to the harm. And here's the controlling question: is the harm that occurred the kind of harm that made the defendant's conduct negligent? I see something that we can fix real quick, and then we are going to resume. So let's stop our share for a moment and let us now re-establish our share. One moment, please. And then we're going to restart our show from the current slide. And there it is. Is the harm that occurred the kind of harm that made the defendant's conduct negligent? That is the normative boundary moment. Did the harm that occurred materialize from the risk? See the connection? What's the risk? What was the actual harm that materialized? Are those two things aligned? If they are aligned, that means liability continues. What do I mean by liability continues? That means that proximate cause is established. Liability continues means proximate cause is established. Got it? Stop. Think about it for a moment and tell me your thoughts. Here's a great place to stop. I'm going to even stop the share because here's a great place to stop. Consider your options. Make sure that you understood the step one, the step two, the step three. And if you did, then we're ready to go to step four. But before we go any further, I really want you to take this moment, maybe stop the video, maybe rewind just a bit, just enough to get to the step one, because it's really important that we're on the same page. Okay, ready? All right. So I have reinstituted the share. Let's keep going. Now that we know the 3-step algorithm, let's practice. And we're going to practice with this list of cases. starting with Paul's graph. Okay. Paul's graph, we're going to apply the risk rule algorithm. Ready? What are the facts of Paul's graph? Well, you remember, we've got a passenger running alongside a train, carrying a package, trying to get on the train while the train is moving. You have an employee of the train on the ground running alongside the train, and you have a train employee in the car that's moving. The employee on the ground is trying to help the passenger who's trying to check the train, who's trying to catch the moving train. The employee in the cart is trying to help as well. The two of them together are able to successfully get the passenger on the train. However, the passenger is carrying a package. Remember the package? It's covered in brown paper, but it's nondescript. We don't know that what's in the package are fireworks, and the fireworks are explosive. And the jostling to get the passenger on the train, the package falls, the fireworks explode, the fireworks set off a shock wave, the shock wave travels down the platform and hits a luggage scale. The luggage scale falls off balance, falls on to Miss Paul's graph, and Miss Paul's graph is now injured. Got it? Right? Let's apply the Rule 29 three-step risk rule algorithm. Ready? Step one. What danger made the defendant's conduct unreasonable in the first place? Well, what were they doing? What happened? The train employees were assisting a passenger trying to help him board a moving train, right? Trying to help a passenger board a moving train. So that's the act. That's the behavior. That's the act. What risk is associated with that? Well, there's lots, but let's just name a few. One of the risks is the passenger who's being helped upon the train may fall and get injured, right? What's another risk? Someone nearby might be hit, right? The employee that's running alongside trying to help hoist the passenger with the package up, that employee might run into somebody who's standing close to the train, standing close to the platform. As the passenger is being hoisted up, we've got limbs flying everywhere. Someone could be struck, right? What's another possibility? While getting on the train, once on the train, right, the employee could be injured, the passenger could be injured again. So there's several potential ways that this risky behavior can create a problem for other people, including the passenger himself. That's step one. So, what was the danger? What's step two? What harm actually materialized? Well, the harm that actually materialized was bodily injury, right? Bodily injury from an explosion. Yeah. All right. Well, does the bodily injury from an explosion align with any one of these potentials? Passenger might fall, somebody nearby might get hurt. I don't know. The object might get broken, right? Any of those things. Does the harm of a bystander suffering bodily injury from an explosion align with the potential risk? The answer is no. Because the answer is no, proximate cause fails. Get it? So, interesting. If you remember, When we analyze Paul's graft under Cardozo, there was no liability. But the reason that there was no liability was because, according to Cardozo, the train company, the employees, did not owe a duty to Miss Paulsgraf because Miss Paulsgraf was not a foreseeable plaintiff because she was not in the zone of danger, right? So the answer is no liability, just like the answer under the third restatement of torts, section 29, there's no liability, but the reason is different. Got it? All right, let's go to Wagon Mound. What's going on in Wagon Mound? Now, depending upon what your professor may have assigned you, there is a Wagon Mound 1 and there is a Wagon Mound 2. For the purposes of this video, we only cover Wagamound 1. For the purposes of this video, we only cover Wagamound 1. So what happened in Wagamound 1? Basic facts. We've got a defendant who are operators on the ship. The ship is docked in Sydney Harbor. Some of the people on the ship, the workers on the ship, want to get rid of some furnace oil. So what do? They dump the furnace oil in the harbor. What do we know about oil and water? Well, they don't mix, right? So the oil is going to stay at the top. It's a surfactant. It's going to stay on top of the water. Now, the oil is going to spread across the surface of the water, and it drifted into nearby wharves. At a neighboring wharf, workers were conducting welding operations. Molten metal and sparks fell from the welding activity onto the floating debris, the water, and ignited. What do we know? It's just burning on top of the water because that's what oil is going to do, right? If you ever learned how to cook when you were growing up, you were always told that if you were using grease, you never put water on a grease fire. It's not going to out, right? And so that's what happens. We've got a wharf now on fire. While it's in the harbor, what's burning is the oil, and the damage that gets done is the plaintiff's wharf burns down. The plaintiff's wharf that's in the harbor burns. So the plaintiff who lost their wharf to fire damage is now going to sue the defendant. Let's apply this Section 29 scope of risk algorithm. And just for purposes of study, I want you to see that we did do a issue statement here. And to fix this issue statement very quickly so that we can actually see what the issue statement says, I'm going to make a bit of a modification here just so that you're better able to see how we wrote this three-part issue statement. And so we are now going to reinstitute the share. And let's see, can you see it? You should be able to see it right there. Under negligence principles is a defendant who negligently discharges oil into a harbor liable for damages when the type of harm, fire, was not reasonably foreseeable, even though the damage followed directly from the negligent act, right? That's one way to frame the issue statement. So what do I have going on? I've got a defendant who negligently discharges oil. Great. I've got a fire that results from the oil in the harbor. Great. Trying to figure out, is the defendant going to be liable for the fire damage from that fire when it was the fire, right, the act of the defendant, in fact, that resulted in the damage? Well, let's answer the question. How do we answer the question? Let's start with step one. Step one, what risk made the conduct negligent, right? What risk made the conduct negligent? Well, they discharged the furnace oil into the Sydney Harbor. Great. What risks are associated with that? Well, pollution risks, right? You've got foul of the wharves, you've got contamination of the water, you've got property damage from the pollution, right? The oil. You've got economic loss from the oil. You might have some damage to the water life that lives there, either plant or animal life that lives there, right? But these are pollution risks, right? These are all pollution risks, right? And so, step one, what are my risks? They're pollution risks. Lots of different ways it can happen, but it's pollution risk. Great. Step two, what injury actually materialized? The plaintiff's wharf was burned down. So we've got fire damage, which is what actually materialized. Okay, let's do an alignment. Did the risk, the pollution, become the harm, the fire damage? No. The oil spill created risk of pollution, risk of contamination, not risk of fire, right? The harm that occurred was the result of fire. There is no alignment, which means liability stops, which means proximate cause is not established. So this is how we get the statement that you can be negligent but not liable. Or put another way, just because you're negligent doesn't mean that you are also liable. Got it? Here's the doctrinal contribution when it comes to the Wagamama case. When, in other words, when we look back at this reflectively, what are we walking away with? Because fire was not within the foreseeable risk that made the conduct negligent, that's the dumping of the oil, right? The welding lacks alignment. Liability is limited to harms resulting from the risk that made the conduct negligent. Fire was not a risk. There's no alignment, therefore, there's no liability. Get it? Yeah? Under Section 29, I'll say it for the 10th time now, liability extends only to harms that result from the risk that made the defendant's conduct negligent. Paul's graph showed us a situation where the harm fell outside the risk category, which means liability stopped. Wagamama showed us another example where the harm that occurred, the fire damage, was not the type of harm that made the conduct negligent, right? The type of harm that made the conduct negligent was oil pollution. In both cases, liability stopped because the type of harm was outside the risk that made the conduct negligent to begin with. Now, I want to also take this opportunity under Section 29 to introduce and discuss the thin skull rule. What if the type of harm is exactly the harm that we expect, right? So our step two question, what is the type of harm that was suffered? It's the type of harm that we expect. The issue is the extent of that harm, the extent of the injury is far greater than anyone could have ever predicted. Is the law going to hold the defendant liable when the degree of harm is so much greater than could have been anticipated? The answer is yes. Ergo, the statement, the defendant takes the plaintiff as they find them. The defendant takes the plaintiff as they find them. For instance, suppose a defendant's negligence creates a risk of bodily injury. Okay, right now we're just talking in general terms. Suppose a defendant's negligence creates a risk of bodily injury, and bodily injury actually occurs. But let's say the plaintiff happens to have a fragile skull, or the plaintiff happens to have a blood disorder, or some unusual medical vulnerability. And what would be foreseen is bodily injury, but not catastrophic. And what is actually materialized is catastrophic injury. Can the defendant argue any reasonable person would have only seen a minor injury, not this severe injury? No, right? That is where the thin skull rule, sometimes called the eggshell plaintiff rule, comes into play. A defendant must take the plaintiff as the defendant finds the plaintiff. In other words, once the defendant's negligence produces the type of harm that made the conduct negligent, the defendant is responsible for the full extent of that harm, even if the injury is unusually severe because of a condition of the plaintiff. Foreseeability applies to the type of harm and the risk, right? It doesn't limit liability to the magnitude of the injury. For instance, if negligent driving creates a risk of bodily injury and bodily injury occurs, liability extends, even if the injury turns out to be far worse than expected. Understood? So let's take the thin skull rule. Let's apply our algorithm and let's see if it holds. Here's an illustration. A driver negligently runs a red light and strikes a pedestrian. The pedestrian has unusually fragile skull. The collision causes catastrophic brain injury. The plaintiff, the pedestrian, sues the driver. Is the driver liable? Is the driver liable? Step one, identify the risk that made the conduct negligent. I asked this question. What danger made the defendant's conduct unreasonable? Running a red light? What is or what are the foreseeable risks associated with running a red light? Collision, bodily injury, property damage. Get it? Get it? The thin skull rule doesn't operate in step one. Okay, let's go to step two. Identify the harm that occurred. What was the harm that occurred? Brain injury. That's a bodily injury, right? Again, the thin skull rule does not operate here. Well, there's only one more step. Step three, align the risk to the harm. Now, we're asking the controlling question. Here it is. Is the harm that occurred the kind of harm that made the defendant's conduct negligent? Yes. Really? Really? What kind of harm occurred? Bodily injury. What was the kind of harm that is a risk associated with the injury? Bodily injury. I have alignment. Get it? I have alignment. And if I have alignment, then what does that mean? That means that liability extends. And if liability extends, what does that mean? Liability extending means that I now have proximate cause. That is the end of video 1. That is the introduction, the explanation, the exploration, and the application of third restatement of torts, section 29, proximate cause, and its algorithm. That's the end of video 1. Looking forward to seeing you with video 2.